This is Barry Zalma, speaking for Claims School Incorporated. Today I'd like to speak about insurance is a necessity and how the law of unintended consequences costs the insurance industry and those who buy insurance. Neither the courts nor the governmental agencies seem to be aware that in modern capitalistic society, insurance is a necessity. No prudent person would take the risk of starting a business, buying a home, or driving a car without insurance. The risk of losing everything would be too great. By using insurance to spread the risk, taking the risk to start a business, buy a home, or drive a car becomes possible. Insurance has existed since a group of Sumerian farmers more than 5,000 years ago scratched an agreement on a clay tablet that if one of their number lost his crop to storms, the others would pay part of their earnings to the one damaged. Over the eons, insurance has become more sophisticated, but the deal is essentially the same. An insurer, whether an individual or a corporate entity, takes contributions, premiums, from many and holds the money to pay those few who lose their property from some calamity like fire. The agreement, a written contract to pay indemnity to another in case of a certain problem, calamity, or damage that is fortuitous, that is, that occurs by accident. That is called insurance. In a modern industrial society, almost everyone is involved in or with the business of insurance. They insure against the risk of becoming ill, losing a car in an accident, losing business due to a fire, becoming disabled, losing their life, losing a home due to a flood or earthquake, or being sued for accidentally causing injury to another. The insurers, insureds, or people damaged by those insured are dependent on one another. In a country where human interactions are governed solely by the terms of written contracts, insurance would be a simple means of spreading risk and providing indemnity based on the promises made by the contract of insurance. But in this real world, insurance contracts are controlled by statutes enacted to ostensibly protect the consumer of insurance, regulations imposing obligations on the conduct of insurers, and the decisions of trial and appellate courts interpreting insurance contracts. A simple insurance contract between two parties might say, quote, I insure you against the risk of loss of your engagement ring valued at $15,000 by all risks of physical loss except wear and tear for a premium paid by you of $15, close quote. Anyone who could read would understand that contract. If something happens to damage, destroy, or lose the ring, the insurer will pay you $15,000. However, insurers cannot write such a simple contract because the state requires many terms and conditions that complicate the policy wording and confuse the common person. The states and courts that did so had nothing but good intentions to protect the consumer against the insurer and control the actions of the insurer. Now, some examples of unintended consequences are the statutes that required simplified wording, and by so doing, caused insurance contracts to become ambiguous and difficult to understand. Insurance contracts can be simple or exceedingly complex depending on the risk taken on by the insurer. Regardless, insurance is neither more nor less than a contract whose terms are agreed to by the parties to the contract. Over the last few centuries, almost every word and phrase used in insurance contracts have been interpreted and applied by one court or another. Ambiguity in contract language became certain. However, the average person saw the insurance contract as incomprehensible and impossible to understand. Courts struggling to understand policies of insurance added to the concern of legislatures. As said in the Insurance Company of North America versus Electronic Purification Company, a 1967 decision, quote, "The insurance company gave the insured coverage in relatively simple language, easily understood by the common man in the marketplace, but attempted to take away a portion of this same coverage in paragraphs and language which even a lawyer, be he from Philadelphia or Bungay, would find difficult to comprehend. Ostensibly to protect the public, to salve the concern of jurists like the one quoted above, insurance regulators and legislatures decided to require that insurers write their policies in easy-to-read language. Because they were required to do so by the law, the insurers changed the words in their contracts into language that people with a fourth-grade education could understand. Precise language, interpreted by hundreds of years of court decisions, was disposed of and replaced with imprecise, easy-to-read language. For examples of an easy-to-read or plain English statutes, go to my book, It's Time to Abolish the Tort of Bad Faith, and read these easy-to-read courses and policies in Appendix 1. The law of unintended consequences came into play. Instead of protecting the consumer, the imprecise language resulted in thousands of lawsuits determined to impose penalties on insurers for attempting to enforce ambiguous, easy-to-read language. The lawsuits cost insurers and their insureds millions of dollars to get a court opinion that interpreted the language and reword their easy-to-read policies to comply with the court decisions. For more than 30 years, the law of unintended consequences struck the insurance industry that found that a law designed to avoid litigation resulted in exactly the opposite. The attempts by the regulators and courts to control insurers and protect consumers were made with the best of intentions. And the old saying that the road to hell is paved with good intentions applied. The judges and regulators found it necessary to protect the innocent against what they perceived to be rich and powerful insurers. Unfortunately, the plain English statutes had the opposite effect. But of course, even after it became clear that easy-to-read policies cause more problems than they cure, the laws and regulations have not been changed. Another example of how good intentions have cost the insurance industry is the start of the so-called tort of bad faith. In the early 1950s, the California Supreme Court created a tort new to the pantheon of U.S. jurisprudence, the so-called tort of bad faith. Remember, a tort is a civil wrong from which one person can receive damages from another for multiple injuries to person or property. The tort of bad faith was created because an insurer failed to treat an insured fairly, and the court felt that the traditional contract damages were insufficient to properly compensate the insured. the court allowed the insured to receive. Therefore, in addition to the contract damages that the insured was entitled to receive under the terms and conditions of the contract of insurance, had the insurer treated the insured fairly, damages for emotional distress and punitive damages to punish the insurer for its wrongful acts. Insureds, lawyers for insureds, regulators, and courts across the United States cheered the action of the California Supreme Court for providing a fair remedy to abused insureds. Most of the states emulated the California Supreme Court and adopted the tort created by the California Supreme Court either by statute or by court decision. After the creation of the tort of bad faith, if an insurer and insured disagreed on the application of the policy to the factual situation, damages were no longer limited to contract damages as in other commercial relationships. If the court found that the insurer was wrong, it would be required to pay the contract amount and damages for emotional distress, pain, suffering, punishment damages, attorney's fees, and other damages the insured and the court could conceive in order to deter other insurers from treating their insureds badly. The good intentions of the courts and regulators led to thousands, multiple thousands of lawsuits that they believed would deter the wrongful conduct. The courts and legislatures adopting the tort of bad faith hoped that the tort of bad faith would have a salutary effect on the insurance industry and force insurers to treat their insureds fairly. However, with claims for $40 wrongfully denied resulted in a $5 million verdict, juries unaware of the reason for an operation of insurance decided that insurers did not pay claims because they were evil and that they wrote contracts so that they never had to pay. The jurors were convinced it was appropriate to punish insurers severely, even when the insurer's conduct was correct and proper under the terms of its contract. The jurors and judges were not informed that over the centuries insurers paid out more in claims and expenses than they took in premiums, making profits only by wisely investing the premiums they held in reserve to pay claims. The massive judgments were publicized, and many insurers decided fighting their insureds in court was too expensive, regardless of how correct their position was on the contract. They found it less expensive to pay than to fight, just as shop owners threatened by the mafia decided it was better to pay protection to the mob rather than to try to fight them. Most of the massive verdicts were reversed or reduced on appeal. The bad actors raised their premiums and lost little business. Other insurers, faced with the massive verdicts, allowed fear to control reason and paid claims that were improper or fraudulent. The extra cost was passed on to all insurance consumers. The insurers who acted improperly were punished less than the honest insurers who were threatened with punitive damages. The insurers who treated their insureds badly, in fact, profited, since they continued their wrongful acts and only were required to pay the few insureds that got around to suing them. Those that did not sue added to the wrongdoing insurers' profit margins. Honest insurers paid frauds and claims they did not owe and found they needed to raise premium charges to cover the extra expenses. The increased premium paid by insureds to cover the extra expense were a clear example of the effect of the law of unintended consequences. The honest insurers who treated those they insured with good faith and fair dealing, who paid off fraudsters and paid uncovered claims to avoid bad faith suits needed to charge more than the bad faith insurers who litigated with their insureds. The law of unintended consequences struck the insurance industry and the insurance buying public. Rather than deter wrongful actions by application of the tort of bad faith, the law of unintended consequences resulted in punishing the honest and correct insurers, honoring the insurers who acted in bad faith with profit, and allowed many insurance fraud perpetrators to succeed. For example, in Texas, the Texas Court of Appeal found that although potential sanctions against both sides were proposed and discussed in the formulation of a statute, it was ultimately decided that such matters were better not specifically addressed. Both prosecutors and defense lawyers were leery about the application of express sanctions. In the end, the consensus was that since courts already possess the inherent power to order remedial and sometimes punitive sanctions, it was best left to the remedies that already existed, rather than trying to write a set of rules or guidelines that could produce unintended consequences for both sides. This was a case called Love versus the State, a 2020 decision. Similarly, in New Mexico, where a jury found an insurer acted in bad faith, and it was well settled that punitive damages may be awarded in insurance bad faith cases, applying a precedent to reach the merits of the insurer's appeal opened the door to unintended consequences by signaling to litigants that they may obtain appellate review of any and otherwise unpreserved jury issue simply by characterizing it as contrary to law. This video was adapted from my book, It's Time to Abolish the Tort of Bad Faith, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video interesting or useful to you, and you watched it on Rumble, please click on the Rumble button. And if you watched it on YouTube, please click on the like button. Thank you for your attention.